good afternoon, ladies and gentlemen, depending on where you are. On behalf of the maritime practice of Fenech and Fenech, it gives me great pleasure to welcome you this morning. And it is really wonderful to see so many colleagues of ours who have actually registered for this webinar, coming from a great number of many different countries. We've got people from Ireland, we've got people from Croatia, Cyprus, Italy, Germany, Greece, England, Turkey, Spain, the Netherlands, Brazil, Florida, Poland, Portugal, Canary Islands, and of course, Malta. Thank you for tuning in to this first webinar in the Fenech and Fenech Maritime series, Talks with the Industry. As a number of you know, we at Fenech and Fenech normally organise a maritime seminar once a year. Well, that went straight out of the window last year, and we had our first virtual seminar. But then this year we thought of doing something different. Also, perhaps, in part celebration of our 120th anniversary. Yes, we are 120 years old this year. So we decided to not have one webinar, but have a series of 4 webinars, which will be spread throughout the year, because there are so many things happening at the moment, which really merited 4 one-hour sessions. We are hugely honoured, of course, that our guest speakers have accepted our invitation to address this webinar. So many thanks, of course, go to Professor Charles Debattista, to Neil Gibbons and Alex Montebello. Of course, none of our distinguished guests actually need any form of introduction, but I'm still going to go through the introductions for good order. So first we have Professor Charles Debattista, who practices at the English Bar in the areas of charter parties and bills of lading, international trade and letters of credit. In international commercial arbitration, he has a thriving advocacy and advisory practice. He also writes experts' opinions for use in foreign courts and tribunals, and has also sat as arbitrator in countless arbitrations over the last 20 years in England and elsewhere under various arbitral rules like the LMAA, ICC, LCIA, SCMA, and SCAI rules. Widely published and cited, he has been closely associated with many of the main instruments used in shipping and trade law, spanning from the UK's Carriage of Goods by Sea Act in 1999 to the relatively brand new ICC's Incoterms 2020. Educated in Malta, Charles qualified as an advocate in Malta in 1978, while at Oxford as a Rhodes Scholar. After a long academic career, Charles was called to the English Bar in 2004 and is now head of 36 Stone, a set of chambers specialising, as you know, in shipping, international trade and international arbitration. Mr. Neil Gibbons. Neil, as a number of you know well, of course, joined Steamship Mutual when he joined in 1990 after working for a British ship owner. He has been a claims handler for members based in Asia and a claims syndicate manager in the European syndicate. Neil is the club's correspondent manager and sits on the International Group Correspondent Subcommittee. Additionally, Neil's duties as communications manager include working on the club's publications and the social media accounts on Twitter and LinkedIn. And boy, wasn't this year a particularly special year for you, Neil, with the need and requirement for social media being never as pronounced as it has been in the past few months. Our third guest speaker, Mr. Alex Montebello. Mr. Alex Montebello was appointed CEO of Malta Freeport Terminals in 2014. He started his career at Malta Freeport in 1989, at the time of the company's inception, and has since then occupied various positions within the company. In his early days as an IT specialist, Alex was responsible for implementing the terminal operating system alongside the company's development and expansion. Following this, Alex oversaw the business development of the terminals and the negotiation with shipping lines, resulting in Malta Freeport's client mix. Alex was then appointed director responsible for the operations of the terminals. He serves as a board member on the Malta Maritime Forum and heads the marketing and international subcommittees. Thank you so very much indeed for our guest speakers and for agreeing to be with us this morning. Our guest speakers today are joined by two of our own Fenech Fenech lawyers. The first being Dr. Adrian Attard. Adrian is a partner in the firm's Marine Litigation Department. He has a wealth of experience in maritime claims, handling most types of wet and dry shipping disputes, ranging from collisions to salvage, and from insurance claims to bunkering disputes. He regularly deals with ship arrests, mortgage enforcements, and judicial sales of vessels. Adrian also focuses on debt recovery and the enforcement of foreign judgments and arbitral awards in Malta. Adrian graduated from the University of Malta in 2009 and holds a master's degree in international maritime law conferred by the IMO International Maritime Law Institute. He was admitted to the Maltese bar in 2009. Adrian obtained a PhD from Queen Mary University of London in 2019, and Adrian is also a very active member of the Malta Maritime Law Association. With Adrian, we have Peter Grima. Peter's main areas of practice include ship finance and ship registration and energy and natural resources law. He focuses on the registration of vessels and yachts and sales and acquisitions of vessels, and regularly assists international banks as lenders in transactions involving mortgage registration over Maltese flagged vessels, as well as Maltese and non-Maltese shipping companies in their capacity as borrowers and mortgagors. Peter also regularly assists in general, corporate, and commercial matters. Finally, this morning's session will be moderated by Dr. Michael Agius. Michael is an associate at Fenech Fenech and works in the Marine Litigation Department. He graduated as a Doctor of Laws from the University of Malta and then read for a Master of Laws degree at the International Maritime Law Institute. Michael has developed a deep knowledge of employment law and is very enthusiastic about maritime law. And this area, of course, marrying employment law with maritime law, is something which is attracting much attention and focus, particularly at the moment. So without further ado, ladies and gentlemen, I leave you in Michael's capable hands, and thank you so much for joining us this morning.
Good day, everyone. Thank you very much, Anne, for that introduction. So I'm very happy and excited to be here, and I'd like to get the ball rolling. So I'd like to start off this discussion by asking Professor Debattista first, primarily, a few questions relating to the enforcement of EU judgments in the UK. Professor Debattista, as we all know, very substantial numbers of maritime disputes are referred to arbitration in London. Did you see a decline in references to arbitration in London as a result of Brexit? And is Brexit, in fact, likely to have any effect on this at all?
Fine, thank you very much indeed, Michael. And can I start by saying thank you very much indeed to Anne and to Fenech Fenech, A, for organising this, and B, for inviting me to speak. It's always a pleasure to speak back in Malta, despite the background behind me, which gives you a lovely view of Gray's Inn Gardens, which is where our chambers are. I'm not actually in England at the moment. I'm in Malta thanks to A, the fact that I have a home here, and B, thanks to the fact that we are in the middle of COVID, with the sort of travel arrangements, travel restrictions that we have. Okay, so arbitration, Brexit. I'm going to park and leave to one side what I really feel about Brexit. I don't think I want to bore you with that. But if we leave that to one side, as Anne very kindly said, my practice is largely as counsel, but also as arbitrator. So obviously, when Brexit came, and then to make matters worse, COVID came, I thought personally, and we thought across chambers, those of us who practice in international arbitration, oh my God, what's going to happen here? We're now a year on, and although COVID has brought terrible news, and Brexit too has brought terrible, I said I would park it, but I'm not going to, and Brexit too has brought terrible news. The fact of the matter is that looking at this dispassionately, there's been precious little impact on the number of arbitrations going through London. And thinking about this for this session, I think there are two sets of reasons for this. Some of them legal, which I'll start with, some of them practical. First of all, arbitration, of course, was always in a parallel universe to EU legislation. In other words, the Brussels recast didn't apply to arbitration because of the so-called arbitration exception or arbitration exclusion. So as a concept, as a practice, it was always at one remove, as it were, from the EU regime. Secondly, the TCA, the Trade and Cooperation Agreement, which was signed on Christmas Eve of last year, which saw us out of the club, it said nothing at all about jurisdiction, much less about arbitration. So as far as arbitration is concerned, there is no new regime because there never really was a regime, and there is no new regime post-Brexit. The third legal reason, so there's no legal superstructure which applies to London-seated arbitrations. The third legal reason why it's had little impact is this. The value of an arbitral award is gauged by its enforceability. No one wants to go through the trauma of an arbitration process without being able to enforce the award, if you win it, of course, at the end. Now, the enforceability of awards, as everyone around this screen and everyone listening to us will know, depends not on any instrument of European legislation, but on the New York Convention on the recognition and enforcement of arbitral awards. That, of course, the 1958 NYC, the New York Convention, is not an instrument of the EU. And indeed, Article 73.2 of Brussels Recast has a special section saying this regulation does not impact anything under the NYC. So, putting those three legal reasons together, membership of the EU, some of you may remember, are being a member of the EU, membership of the EU had no impact on the passage of arbitration through the City of London. And if membership had no impact, neither, of course, does Brexit, as is. There are also practical reasons why the last year has had no impact. First of all, when I look at my desk back in England, or now at my virtual desk here in Malta, the vast majority of arbitrations which I deal with, whether as counsel or as arbitrator, have parties, frequently both parties, neither of whom has anything to do with the EU. That's the nature of London. It's the nature of arbitration. It is relatively rare. It's not rare, extremely rare, but relatively rare that I have an arbitral party which is located in the EU. Very much more common to have at least one party outside the EU and many parties, both of whom are outside the EU. That may just be because of the industry sectors that I operate in, mainly shipping and trade. So that's the first reason why Brexit has not had an impact. But there are other reasons, which brings me to COVID in a sense. London, I have to say, we really hit the ground running in March or April of last year, by which I mean we weren't phased in my field, in commercial law, shipping law, trade law, by the fact that we had to go virtual. And in a sense, it was arbitration that led the way. If you're arbitrating, it's private justice. People are paying money for the service. You can't just say, whoops, COVID, let's wait for a year or two. You just have to get on with it. And arbitration led the practice of resolving disputes by Zoom and other platforms. The courts followed soon after. So the fact of the matter is that the last year hasn't really had an impact. So that, to conclude then on your first question, a year ago today, those of us in legal practice in London thought, oh my goodness, this is going to be a double whammy. We've just left Brexit. We've just been, like the Duke of York, led up the hill. God knows what's going to happen now. So that's the first part of the whammy. The second whammy was COVID. What's going to happen to practice, to arbitrations in particular? And the answer was not a lot.
So we have around 3 minutes left of allocated time in relation to this. I found it very interesting how you mentioned that arbitration is in a parallel universe, so to speak. In fact, my second question is in relation to jurisdiction recognition and enforcement of judgments. So, as you know, these are matters which, between EU member states, are regulated by Brussels I and the Brussels I recast regulations. And now that the UK is out of the EU, out of the club, so to say, how would we, for instance, go about enforcing a Maltese judgment or any other EU judgment in the UK?
Okay, thank you very much indeed for very subtly reminding me that I was in danger of overrunning. So I'm almost out of lay time, so I'll do this really quickly, okay? We've had the hardest of hard Brexits when it comes to jurisdiction and enforcement. There was very little appetite in Q4 of last year as we came right up against the buffers. You may recall December of last year, it was on or off, off or on. Was there going to be a deal? Wasn't there going to be a deal? The deal was sealed and signed by Mr. Johnson on Christmas Eve, on the 24th. No one really had an appetite for, or time indeed, to create a seamless sort of transition post the transition stage in the matter of judicial or indeed arbitral jurisdiction after the end of December. So whereas other areas of our industry have not had a hard Brexit, this one has had a hard Brexit. What does this mean? What it means is that whereas before you had the dynamic of sort of automatic reciprocity through effectively the registration of one judgment in one country, enforcement in another, we've now gone into a void. Perhaps not a void, perhaps I should say a fog. Because of course, the UK, England and Wales, has its own system whereby you screen the enforcement from third states into the enforcement of judgments achieved in third states, like take the United States, into the jurisdiction. So now we are a third state, you are a third state, in other words, the EU is a third state. So various bits of legislation which we used to apply to what I still like calling proper third states are now applied to our new colleagues and partners, the third state of the EU, e.g. Malta. Now, of course, the difficulty with enforcing a judgment in England is that the other side is going to use any tool that they might have, any domestic tool they might have, in order to resist enforcement. The idea being, I mean, I have an arbitration at the moment, and we can see which way the wind is blowing. So we're fighting the arbitration. We're also fighting the eventual enforcement, which will happen in an EU state. So I have one eye on what we're doing in the London arbitration, but another eye on how we're going to resist enforcement. Now, we are in exactly that situation now, where the other side, the judgment debtor, if you like, in England, with assets in England, is going to try their best to use any number of rather more detailed, I mean, if you think the Brussels recast is detailed, the local domestic legislation is far more detailed. And quite frankly, anyone whose assets you're trying to enforce upon in London is going to have a field day trying to resist that enforcement. It's the same thing, if I may just run very quickly to the end, with security. Whereas before, the Brussels recast saved security and said, you know, if you have a litigation going on in country A, but you want to get security in country B, both members of the club, then the fact that the merits are being dealt with in country A, but you're trying to get preventive measures in country B, doesn't matter. You can split jurisdiction like that. Well, now we're not part of the club. So now you fall into a void, into a fog of local domestic measures. And I'm not saying that that isn't navigable, but here I'm shooting myself in the foot. It's much more, it's navigable with much more difficulty, more cost. If I can just tie up with where I started, what is the net result, I suspect, over the next 2 or 3 years, while all of these legal issues are dealt with in the courts in London? I think that we will see an uptick in arbitration clauses away from jurisdiction, because one of the advantages of arbitration is that you're outside this universe, and therefore it may be much easier. Enforcement, in particular, is subject to New York, not to EU or Brexit. Thank you very much. Sorry if I have outstayed my welcome.
We have in fact a lot of time, unfortunately. I had another question prepared. Maybe we can get back to it if we have any time remaining at the end of the session, if that's okay. Thank you very much, Professor, for that very detailed analysis. Now that we understand the position in the UK, I think it's best to look at the flip side of the coin and have a look at the position in Malta. So we've prepared some questions for Adrian, and we'd like to hear your thoughts, Adrian, if I may. In your opinion, what impact is Brexit going to have on the way in which UK judgments are recognised and enforced in Malta?
Thank you, Michael. Well, obviously, it's going to have a significant impact. Up until last year, the procedure was generally quite straightforward. It was regulated by the provisions under the Brussels 1 regulation and the Brussels recast regulation. Most notably, the process under recast allowed for a very efficient cross-border enforcement of foreign judgments. Now that the UK is out of the EU, the matter is slightly more complicated, and we must make a distinction between judgments relating to legal proceedings which were instituted pre-Brexit and those instituted post-Brexit. Pursuant to the EU-UK withdrawal agreement, the enforcement proceedings in relation to judgments which given in legal proceedings instituted before the end of December 2020, the provisions of the recast regulation will continue to apply. And therefore, in our view, at least in mine, the next year or so, we will still be seeing enforcement proceedings regulated by the recast regulation. However, going beyond that point, the matter would fall squarely back to Maltese domestic legislation. On a side note, I wish to point out that there are, of course, other international instruments which regulate the cross-border recognition and enforcement of judgments, such as the 2005 Hague Convention on Choice of Court Agreements and the 2007 Lugano Convention. However, although the EU acceded to the Hague Convention, and I know that the UK as well, in its own right, has acceded to the Convention, the provisions have not yet been transposed into Maltese law, and it is questionable, therefore, whether a Maltese court of law would enforce the provisions of that convention. With regards to the Lugano Convention, as of yet, the UK is not a state party, so we have to watch the space, so to speak. But for the time being, post-Brexit enforcement look like they will be regulated by Maltese domestic law. Now, the general provisions on the recognition and enforcement of non-EU judgments in Malta is governed by the provisions found under our Code of Organisation and Civil Procedure, which we colloquially refer to as the COCP. And the COCP basically affords a claimant the right to enforce any foreign judgment given by a competent court as long as it is a res judicata, a final and non-appealable judgment. Again, even this is different from the position under the EU regime, where you can even have enforcement of provisional judgments. However, I think the biggest setback of proceeding under the provisions of the COCP is that the grounds for refusal are much wider and more encompassing than those found under the regulation. So as Charles pointed out, if you have a debtor who has an appetite for litigation, he can try to come up and resist recognition and enforcement as in a much, he have more tools available to him. Another probably limitation of the general provisions is that it is the procedure, it takes the form of a normal action. So you have you file a sworn application, there is a reply, the court has to hear the merits, and then there is the right of appeal. So it could also be time consuming. However, there are exceptions to these general rules, and apart from obviously the prevailing nature of EU regulation, there is another exception which is pertinent to today's discussion. The general rules found under our CLCP are also superseded by the provisions of Chapter 52 of the Laws of Malta, entitled the British Judgments Reciprocal Enforcement Act, which is an old colonial piece of legislation enacted in 1924, but effectively caters for the provision of enforcement of UK judgments in Malta. Now, I'm not going to go into the nitty-gritty of the Act. However, some advantages are that it is a much more speedy process because you go straight to the Court of Appeal. And another, in my view, advantage is that there are much more restrictive grounds upon which a challenge may be brought. The flip side, and perhaps the limitations of the Act, is that it only applies to judgments given by the superior courts of the UK and limited to pecuniary judgments, so judgments whereby sums of monies are made payable. It would appear that with other types of judgments from the UK, you would still need to follow the general provisions under the COCP. I mean, in conclusion, this Act appears to be a surviving remnant of our British colonial past. However, today, it seems it's going to turn out to be a very useful tool going forward when we map out the post-Brexit enforcement scenario.
So thanks for that, Adrian. You told us a bit about judgments. Now, if we look at arbitration, so where arbitration is concerned, what do you think Brexit as an impact would have on the enforcement of UK arbitration awards in Malta? And just to remind you, you have around 4 minutes left.
The short answer is no, not really. As Charles pointed out, arbitration has always fallen outside of the scope of EU regimes when it comes to recognition and enforcement. The recognition and enforcement of foreign arbitral awards in Malta is regulated by the Arbitration Act and our arbitration rules, which effectively incorporate the provisions of the New York Convention and flesh out the mechanisms to incorporate the provisions of the Convention. The UK is also a state party to the New York Convention, and quite frankly, the bottom line is that the process is going to remain the same. I think the only real change that has been made in this regard will affect all recognition of all foreign arbitral awards, not just UK awards, and it has basically, there was a legal notice last year which introduced a right of appeal on a decision with regards to the recognition of enforcement. Advocates in favor of this amendment will argue that it creates a better equality of arms. However, my personal opinion is I'm not quite sure whether it serves the purpose of the New York Convention, which is basically to have an efficient cross-border recognition of foreign awards. The new amendments are yet to be tested. However, in my opinion, the speed at which the appeal is dealt with will determine whether it serves to improve the system or not.
Thank you, Adrian, for your concise response. And just a final question from my end. On a slightly different note now, given that the UK courts are often seen as a preferred dispute forum, particularly in the shipping industry, as most of our listeners know, now that the UK is no longer part of the EU, will the Maltese courts still be bound to respect jurisdiction clauses referring disputes to the English courts?
An interesting question indeed. Traditionally, the Maltese courts have always been reluctant to declare themselves divest of jurisdiction purely on the basis of the existence of a jurisdiction clause. I guess the EU regulations tied up the court's hands in the sense that under the respective regulations, the Brussels I and the recast, the courts were obliged to respect jurisdiction clauses pointing or referring disputes to the courts of another EU member state. Again, now, in trying to map out the post-Brexit scenario, I guess we have to make a distinction between proceedings commenced prior to the end of last year and those commenced as of this year. So with pre-Brexit proceedings, the court will continue to respect the provisions of recast and therefore will be obliged to adhere to a jurisdiction clause. In fact, earlier this year, we were involved in a case that went before the Court of Appeal, and the Court of Appeal upheld that the Maltese courts are bound by an English jurisdiction clause on the basis of Article 25 of the recast regulation. However, in relation to proceedings instituted post-Brexit, the matter will be again solely fall within the remit of Maltese domestic legislation. And I won't go into the nitty-gritty of the grounds of jurisdiction under Maltese law, but ultimately the Maltese courts will tend to exercise their discretion on a case-by-case basis whether to relinquish a jurisdiction or not. The most accepted position is that the court would first establish whether it would have its own underlying jurisdiction, and if so, it would tend to weigh the principle of freedom of choice of the parties against what, in the court's view, would best serve the interests of justice. So ultimately, it will be, going forward, it will be the courts will probably deal with the matter on a case-by-case basis. So it will become a bit harder to advise clients whether a jurisdiction clause will in fact be recognized and upheld and enforced or not.
Thank you very much, Adrian. And I guess, as you said earlier, we're going to have to watch this space for any developments going forward. I'd like to shift gears now, so to speak, and talk about a bit of a different topic. So I'd like to address a few questions to Peter. As most of our listeners know, Malta Flag is the largest flag in Europe, and it's a highly regarded flag around the globe. So we thought it would be a good idea to see whether Brexit has had any impact on the registration or the effects of registration of vessels in Malta. So, Peter, broadly speaking, how would you evaluate the run-up to Brexit and its effects on the Malta Flag?
Thanks, Michael. Well, broadly speaking, of course, we didn't really view Brexit as a threat to the continued standing of the Malta Flag as what is currently the largest flag in the EU and the 6th largest flag in the world. We rather saw this as an opportunity. The same cannot really be said from the UK perspective. Of course, Brexit led to a lot of uncertainties, and these uncertainties translated into ship owners taking cautious approaches in whether or not to continue utilizing the UK flag or to taking the cautious approach, which is what they in fact did, and reflagging to other EU flags. We saw, for instance, the likes of CMA CGM, which are the 4th largest container carrier in the world, reflagging their entire fleet from the UK flag to predominantly Malta. There were 49 vessels to be reflagged, and 46 of them ended up under the Malta flag. And in the case of CMA CGM, the reason for the reflagging exercise was, yes, largely because of the uncertainty, but also because of the view they attribute to an EU flag, which to them is considered an essential part of their business model. Like CMA CGM, we saw the likes of Wallenius Wilhelmsen, who reflagged their vehicle carriers to Malta. And we also saw the likes of Grimaldi Lines, who also reflagged their Conroe and Ro-Ro vessels to Malta, which are some of the largest types of vessels on the international market. In both these other cases, it was also the uncertainty that Brexit brought about. So they, rather than waiting around to see what implications Brexit would have on their operations within the EU, they sought to reflag immediately. Just to give you a bit of context, though, a bit of a graphic contextualization of what this meant, the UK lost about 34.4% of its gross registered tonnage between 2019 and 2020. And this worked out as a reduction, a shrinking of its register from 16.5 gross tons to about 10.5 gross tons. If we look at it from the Maltese perspective, we had during the same period a 7% increase in our gross registered tonnage, which was at the time the largest percentage increase in the world. So it's clear that Brexit was beneficial to Malta, at least from the Maltese registry's perspective, and it was prejudicial from the UK registry's perspective. And ironically enough, it happened to happen at a time when the UK registry was forecasting an increase, a twofold increase in their gross registered tonnage, but in actual fact, they ended up seeing a contraction of about 1/3.
Peter, to tie up to what you just mentioned now, would you say there are any legal implications on the UK and UK citizens who are now obviously no longer part of the EU in relation to registered vessels?
Yes, there are. There's one major legal implication, which ties up with the eligibility requirements to own a vessel or a yacht under the Malta flag, as many of the Maltese viewers would know. In order for an individual to own a vessel or a yacht under the Malta flag, they need to be either EU, EEA, or Swiss nationals. So the UK leaving the EU obviously brought about a reality that the UK nationals no longer fell under that eligibility requirement. This is obviously more of interest to the yachting sector rather than the commercial vessel sector, because more often than not, as most people know, commercial vessels tend to be registered in the ownership of entities, not individuals. But we always knew that the law would be amended. It was not a matter of if, but when. We obviously value the work that we get from UK nationals who very frequently register their yachts in their personal names. And what was interesting was that the Maltese lawmakers made a timely intervention to kind of add a bit of certainty to the uncertainty of Brexit and amend the laws in a timely manner to make sure that UK nationals would benefit from being able to own a Malta flag vessel in their personal name in the same manner as a Swiss national would.
Thanks for that, Peter. You spoke about the run-up and its impact on the Malta flag. So now that the UK has officially left the EU, in your opinion, what are the reasons that would lead ship owners to choose the Malta flag over that of the UK flag?
So one of the major attractions to the Malta flag is the fact that we are a member of the EU, and therefore having a Maltese flag is having an EU flag. And as we saw with the case of CMA CGM, many ship owners attribute a lot of weight to owning a vessel that is flagged under an EU flag. And it essentially impacts a lot of their operations in some manners. So from that aspect, we gain a lot just by mere of the fact that we are EU member states. But the attraction of the Malta flag transcends the fact that we are EU and therefore have to abide by higher standards by reason of the fact that we are an EU member state. It's also touches upon the financing aspects of a vessel, and many a time the financiers would impose conditions that the flag of the vessel being financed would need to be an EU flag, because EU flags such as Malta would be party to the Tokyo MOU, they would be party to the Paris MOU, and so there would be essentially fewer port state control inspections, which would conversely lead to fewer detentions. And this works out to be both in the interest of the owner and in the interest of the financier. Interestingly though, the financiers also sometimes include conditions for financing that would stipulate that aside from an EU flag, they would also require a flag whose jurisdiction is considered to be typically creditor friendly. And when I say creditor friendly, I don't really want to scare off the ship owners, but Malta has what is considered to be a mortgage that is an executive title. So the mortgage that is the main form of security in a ship finance transaction can be more swiftly enforced than in other jurisdictions. And so for them, that gives them the comfort that on an event of default, the process to enforcement is not a long-winded one, and they can proceed to enforce relatively swiftly upon the filing of a notice of default. So it's a mixture of things that make the Malta flag an interesting flag, and the future augurs well to potentially attracting some of that shipping that would potentially have looked at the UK as a flag to register under, and would now look towards Malta as the #1 flag of choice in the EU.
So, Peter, you just have over 1.5 minutes left, so I'll keep my question brief also. So you mentioned yachts and the tonnage scheme. Would you say, therefore, that Brexit poses an opportunity for attracting British shipping organizations to Malta?
This is certainly the aim. So we look at the ship register as an essential part of the Maltese shipping portfolio, and we're always looking to continue increasing our standing as the largest flag in the EU and the 6th largest flag in the world. But the impetus at the moment is not just geared towards increasing the register, but we're also looking at Brexit as an opportunity to attract shipping organizations that would potentially be looking to relocate to other EU states to conduct at least a part of their business activities from other EU states. And Malta, aside from having obviously its tonnage tax regime, its corporate tax regime, which are approved by the EU and are very favorable and attractive for anyone looking to relocate to Malta, we also have other attributes, which are the fact that we have an experienced workforce, not just in shipping, but also in finance, in insurance, in law in general. We're also a very bilingual country, which is sometimes a bit overlooked. Malta is an English-speaking country where the working language is English. So there's that sense of familiarity. If I were an English business, so to speak, looking to relocate, I would want familiarity. I would want to know that I can communicate easily where I'm going to relocate to. I would want to know that I have the expertise that I need to rely on to conduct my business operations. And I would also want to ensure that the law is something that I'm also familiar with. And in Malta, we happen to be, at least in terms of shipping, our shipping law is based on common law. So overall, there's this sense of familiarity that I believe ship owners would very much, and shipping organizations rather, would very much be interested in when relocating to Malta. If I could just mention one last thing, Mike, if you give me one more minute. We have in the last few years amended our laws to kind of add on to this impetus that's coming, not just from maybe ourselves as stakeholders and the registry itself and lawmakers to attract foreign businesses to Malta. But we've also amended our law to cater for ship management organizations in particular. Now today, ship management organizations pursuant to legal notice 127 and 128 of the laws of Malta will be able to benefit from our tonnage tax system and would effectively pay 25% of the tonnage tax that would otherwise have been payable by the vessels managed. And in order to fall under the eligibility requirements, they would need to either provide crew management services or technical management services. So to sum up, yes, there is this consolidated effort from all sectors of the Maltese maritime spectrum to attract new business potential outposts from traditional UK-based organizations to set up in Malta. These would hopefully include the likes of P&I clubs and ship managers. And if we do manage to continue to attract these organizations to Malta, it augurs well to continue to establish ourselves not just as the leading maritime flag in Europe, but also a leading maritime hub in the Mediterranean.
Thanks, thank you, Peter. So it will be interesting to see whether the trend will change over the coming months and that Brexit has actually taken place. We've looked at the effect of Brexit on registrations in Malta and the attraction of vessels flying an EU flag, the Malta flag. So we thought it would be interesting to hear from the vessels insurers, so their P&Is as massive players within the shipping industry. So I'd like to move on now to Mr. Gibbons. Thank you for joining us, Mr. Gibbons. In your opinion, as someone on the ground, so to speak, what implications did Brexit have for P&I clubs in general?
Thank you, Michael. Well, there are 13 P&I clubs in the international group. A couple of them are based outside the EU EEA area. There's one in Japan, one in the USA. Of the remainder, there's one in Sweden, 2 in Norway, 2 in Luxembourg, and the others are kind of nominally UK based. And for those, the implications of Brexit were more serious for those who are kind of nominally UK based. In the aftermath of the vote, there was a lot of uncertainty that's been alluded to in talks up to now. For some time, there was a discussion, should there be another referendum, and then that faded away. But there was a lot of business uncertainty. It was not clear what kind of deal that the UK would achieve, or even what kind of deal it might seek. And for a long time, a no-deal Brexit was a realistic possibility. So against this kind of uncertain background, the clubs needed to be able to maintain the cover that they provide to their ship owner and charterer members who are based in the EU. They needed to be able to provide that cover and service, however the discussions with the EU resolved. There was a risk that the UK-based clubs would not be able to administer insurance policies issued to policyholders in the EU or EEA. And this became even more likely when it was clear that leaving the EU also meant leaving the single market. At this time, we heard a lot in the press and read a lot about passporting rights, meaning that a company registered in the EU or EEA is able to do business with any other EU or EEA country without having to request further authorization in the country where they want to do business. The loss of these passporting rights for P&I clubs would mean significant bureaucratic difficulties for the clubs, as they would need to seek approval from appropriate authorities or even from the centralized EU itself in order that they could maintain and carry on the ease of business transactions that they previously enjoyed. So the continuity of service to European-based members was important, and this led the clubs to, certainly at Steamship, led us to look to open an office within the European Union itself.
Thank you for that. We're aware that Steamship Mutual is one of the largest and most diverse P&I clubs in the world. What steps did Steamship Mutual think necessary to take pre- and post-Brexit?
Well, our main aim was to provide a continuity of service and cover to our European-based members. And in order to achieve this, we decided that it was necessary to open an office in the European Union. And after looking at various locations, we eventually decided on Cyprus. And this, of course, is not at all an easy process. You had to take legal advice and look at the regulatory authorities in the countries where you're considering opening, and can you comply with the appropriate the regulations that those authorities will require. But beyond that, we also needed court approval to move the business from what was the existing club at the time to a new European entity once it was established in Cyprus. And the Cyprus office is no brass plates office either. It's not just a nominal office. We had to employ people locally and from elsewhere. We had to find premises. We had to redeploy people from other steamship offices as well. So it's a kind of long and expensive process, and it's not straightforward. But the main aim throughout all of this was to be able to continue to provide the level of service and cover to our members based in the European Union.
Okay, in fact, you just went on to a little bit to my next question. So it's a fact which is known throughout that Steamship already has an office in Piraeus in Greece. Why was it necessary to open another office in Cyprus, not Malta, which is another EU member state, which is also geographically so close to Greece?
It's true, yes, true. Steamship does have an office in Piraeus and has had for some time. I think under the terms of the license that office operates, we're not able to do underwriting from that office. And that's really the key point, that we needed to be able to do underwriting from a new EU office. So that's why we had to look elsewhere. I'm very sorry that we didn't open in Malta. There are certain good business reasons why we did open in Cyprus. We have some very good long-standing members there. So Cyprus, in a way, was more a natural fit for Steamship, although I'm sure that there would have been plenty of opportunity in Malta as well. So I'm sorry we weren't able to open there.
It's okay, no hard feelings there. So for my final question, just to sum up what you have just gone over and discussed together, would you say that Steamship's Brexit experience has been good or bad so far?
Well, it's perhaps looking at it in terms of good or bad is not really the way to look at it. Brexit is here to stay. And everybody has to adapt to the post-Brexit world. There's absolutely no political appetite, as I've detected it in the UK, for any kind of further referendum anymore, or any kind of further application to join single market or EU. That's now all done and dusted. Everybody has learned to live with the situation as it is. So we have to adapt to the post-Brexit world. And in terms of the membership of the club, I don't think that the membership, that if we're part of the EU, has any particular impact on membership of the club. People look to join the club or remain in the club for reasons not necessarily connected with Brexit. They look at levels of service and rates, of course. Things like that are important. But of course, the other thing is that if we hadn't opened an EU office, then providing the level of cover and service that we do to the European-based members would have been a lot more difficult. So we had to open the office in the European Union in order to be able to maintain that service. So whilst it's certainly been an expensive and a difficult process, I don't think doing nothing was not really an option. And it's probably fair to say that absent the whole Brexit process, it's unlikely we would have been looking to open another office in the EU or in Cyprus. But that's not to mean that doesn't mean it's a bad thing. So some of the politicians here have been stressing that we've got to look at the opportunities that Brexit provides, and that's certainly true. That the opportunity to open an office in Cyprus, it's been a good one for us. It's brought us closer to our members there, and perhaps also for a big international organisation like a P&I club, being less London-centric is probably not a bad thing. It gives us another aspect, and we can take into account the views of our members based there. It occurs to me as well that the reaction to Brexit is perhaps a bit like the reaction to COVID, that everybody wants to maintain a business as usual approach, and clubs and insurance companies and law firms are all doing their best to maintain that. So we've done our best to maintain business as usual. It's not cheap, and it creates a certain amount of difficulties, but it can be done. And at the end of the day, we are a service industry, and we need to service the members both in the European Union and outside. Thank you.
Perfect, thank you very much, Mr. Gibbons. You're the only one who stuck to your time so far, it seems. So we're going to move on now to another man on the ground. So as you know, the title of this webinar series is Talks with People in the Industry. So we're going to move now to Mr. Montebello. Thank you for accepting our invitation, Mr. Montebello. And we've prepared some questions in relation to the Malta Freeport. Can you maybe give our viewers a description of what the trade passing through the Freeport from the UK to Malta is like?
Yes, first of all, thank you for inviting me to address this interesting webinar about Brexit and the implications on the maritime industry. By way of introduction, Malta Freeport is one of the leading transshipment hubs in the Mediterranean, whereby we handle more than 3 million TEUs annually. We are located right in the center of the Mediterranean, and that gives us an advantage in the sense that we are on the main trade routes for shipping lines. And it makes it easier for shipping lines to make just one call in the center of the Mediterranean to serve both the eastern side of the Mediterranean and the western side of the Mediterranean. Over 96% of our traffic is transshipment business, which means discharging containers from the largest vessels afloat and then backloading on smaller vessels to serve the end destination in the Mediterranean. We are actually one of very few ports in the Mediterranean who can handle the largest vessels afloat, even larger than the now notorious Ever Given, because Ever Given has been given a massive publicity for the wrong reasons in the Suez Canal. Everyone talking about Ever Given and how large this vessel is. Actually, in Malta, we handle even larger vessels than the Ever Given. And through these regular services with the large vessels that are calling at our facilities, we offer connections to more than 100 ports worldwide on a weekly basis. Around 30,000 containers originate from the UK. It's a small number relatively because most of our trade is linked to the Far East and not to Northern Europe in terms of transshipment business. These 30,000 units which originate from the UK are transshipped then from Malta to end destinations, which include the North African region, which are connected through shuttle services practically from Malta. Last year, the local imports from the UK were in the region of 3,000 units, which represents 27% market share from all North Europe. And in 2020, Felixstowe was the port within the UK with the highest throughput with Malta Freeport. However, Antwerp, Rotterdam, and Hamburg still retain the lion's share for Maltese importers and traders. So despite Felixstowe, Southampton, and London Gateway being important connections for local importers, it seems that the Maltese importers are importing more cargo from within the EU, from Antwerp, Rotterdam, and Hamburg, as opposed to the UK.
So thanks a lot for those numbers and putting everything into perspective. And if I were to ask you to tell us a little bit about the weekly services that connect the Malta Freeport to the UK and vice versa, maybe to elaborate a bit upon that point.
Yes. So today we have 5 weekly services that are connecting Malta to the UK on a weekly basis, amongst which the Nemo service, which is operated jointly between CMA, CGM, and MSC, the New Levant service, which is operated between CMA and ONE, and then there are another 2 services, which are the FEMEX, which is operated independently by CMA, but the most important service in all respects is the FAL1 service, which has been notoriously the flagship service of CMA around the world. It is the most important service for CMA around the world. And as of January this year, this service is calling Malta. And in particular, the service is operated with 23,000 TEU vessels powered with LNG. Therefore, the environmental credentials of this service are of particular importance in general to the shipping industry, but also the port rotation is of particular importance because for the first time ever, the transit time from Southampton to Malta is limited to just 4-5 days. And this is thanks to the service which is operated with these largest vessels afloat, permitting the Maltese industry to have a transit time from the UK, which it never had before, because before, previous services which connected the UK to Malta used to call other ports in between the UK to Malta. So for example, before we had services which would call Felixstowe and then call in Algeciras and Gioia Tauro before coming to Malta. This time around, FAL1 is operating directly from Southampton to Malta. And this is also related to the investment which we have undertaken in our facilities, because in order to operate the 23,000 TEU vessels, we have invested heavily in new equipment, in new key cranes which are capable to operate on these Megamax vessels, as well as investment in infrastructure to be able to have enough water depth, 17 meters, to operate these gigantic vessels.
So we have around 4 minutes left, and I have 2 questions. Maybe I can incorporate both into one, and we can conclude in that manner. Yes. So my first question is how, as most of our viewers know, we've seen several news reports and articles on social media referring to UK ports suffering from a post-Brexit disruption. In your opinion, what is causing this disruption, and what impact has the disruption had on the Malta Freeport? And as a concluding question, how would you tie everything up if you were to describe how Brexit impacted Malta Freeport in general?
Well, today the situation in the UK ports is one of congestion, with vessels being diverted by various shipping lines to other destinations, so much so that there are certain shipping lines who are no longer calling with their mainline services and instead are transshipping from Rotterdam to the UK. This is an unfortunate development because this has led also to shortage of empty units in the UK. But I would say that this is more as a result, not just of Brexit, but also, and more importantly, I would say, because of COVID. So the disruption is there. Certain shipping lines, as I said, have already diverted services to other ports. And this has led to a knock-on effect on the schedules of the vessels calling at Malta Freeport, because if you have a vessel which is expected to call in Southampton on a Tuesday, and then it is expected in Malta on a Saturday, and it has that particular window reserved on a Saturday in Malta, that vessel will be delayed by 2-3 days, and now clashing with another service. So it is complicated when there are ports, especially within North Europe, that are congested, and the knock-on effect is obviously absorbed also by the Mediterranean ports. I would say that the enforcement of post-Brexit UK border controls have not had such a big impact on the containerized trade that is transshipped through Malta. Why? Because as a terminal operator, we rely on data that is supplied by the shipping lines through EDI traditionally, and now also through blockchain technology. And as a terminal operator, we do not require to know the contents of the containers, but we require certain operational data according to international standards, which is transmitted on a regular basis. This has not been affected, fortunately for us, by the Brexit rules that have been agreed between the EU and the UK. So the impact was lesser than originally predicted. I cannot say the same thing for local importers, because local importers have to present additional documentation, which is resulting in 2-3 days more dwell time to clear those containers. So the bureaucratic process from a customs clearance perspective is definitely having a higher impact rather than the operational impact.
Thank you very much, Mr. Montebello. Before passing on to Anne again to conclude, I just want to point out to our viewers that in the chat, we have added an email address where you can send any questions since we've run out of time today. Thank you all. Anne?
Thank you, Michael. Well, ladies and gentlemen, we've come to the end of our webinar. Thank you so much, all of the viewers that have participated. I hope you have found it interesting. I certainly have found it interesting. One of the reasons why we decided to have such a varied, so many varied subjects within the Brexit scenario was precisely to make it interesting and for it to be perhaps provide food for thought, shall we say. And as Michael has just said, if you do have any questions, please do not hesitate to get back to us on our email. So thank you so very much for participating this morning. Of course, profound thanks go to our guest speakers. Once again, Professor Charles Debattista, Neil Gibbons, and of course, Mr. Montebello, thank you so much for joining us this morning. Thank you for all the maritime team at Fenech Fenech. There have been a lot of people who have taken part in the organization of this event. It only lasted an hour, but it took many, many days to organize. So thank you all the maritime team. Thank you to Rosette Take, who is our knowledge manager, and to our IT team, who have, of course, been able to deliver so very well indeed over this past year, where we've migrated from having physical events and activities to online and virtual events. So again, thank you for attending this first webinar of ours. And I would like to remind you that this is the first in a series. The next one will be on the cruise line industry. The third will be on judicial sales. And the fourth will be on yachting. So do please watch the space for dates and details. And I certainly hope that you will be able to join us again. Again, the focus will be meeting the industry. So with all these topics, we plan to have guest speakers who can share their thoughts on what it's like on the ground for them. Thank you very much indeed, everybody. And as has become very customary in the age we're living in, do keep safe and take care of yourselves. Thank you very much indeed.